Hi, I'm Dan Cooperstein, and welcome to this episode of Compliance Minute. In the 6-2 decision of Gobel v. Liberty Mutual Insurance Company, issued on March 1st, 2016, the U.S. Supreme Court affirmed a Second Circuit Court of Appeals decision holding that ERISA preempts, that is, supersedes, a Vermont health data reporting statute as it applies to self-insured group medical plans and their plan administrators. The Vermont law at issue requires reporting of health plan claims, cost, and other information to a state database. The law was targeted to health insurers, providers, and government agencies, and defines health insurers to include self-insured health plans and TPAs. The court's decision found in favor of a self-insured ERISA health plan sponsor that challenged the law's application to its plan and sought to prevent the collection of data from the plan's TPA. As background, ERISA generally preempts state laws that relate to ERISA plans. An exception to ERISA's general preemption rule allows certain state regulation of insurers. The majority opinion, written by Justice Anthony Kennedy, concludes that, quote, the state statute imposes duties that are inconsistent with the central design of ERISA, which is to provide a single uniform national scheme for the administration of ERISA plans without interference from laws of the several states, even when those laws to a large extent impose parallel requirements, unquote. The district court that reviewed the matter found that the Vermont statute was not preempted by ERISA as applied to self-insured plans, but the Second Circuit reversed the district court, holding that the Vermont statute imposed a material burden on self-insured plans. The Supreme Court affirmed the Second Circuit's decision, barring Vermont from applying the statute's requirements to self-insured plans. ERISA's preemption provision has been described by the Supreme Court as one of the broadest in any federal law. This extremely broad preemption standard has been the basis for striking down state regulations in a number of Supreme Court cases, especially those where the challenged state regulation applied to what is called a core ERISA function, such as plan administration. The majority decision in Gobel concluded that, quote, reporting, disclosure, and record keeping, which were central aspects of this Vermont statute, are central to and an essential part of the uniform system of plan administration contemplated by ERISA, and that those requirements are integral parts of ERISA, unquote. While the Gobel decision may have seemed like a straightforward application of Supreme Court ERISA preemption jurisprudence, the concurrences and the dissent seem to indicate that the court is not yet finished with defining the contours of ERISA preemption doctrine. Of course, as is the case with many other issues, the views of the next Supreme Court justice, whenever one is confirmed, may result in a change in ERISA preemption jurisprudence. For more information on this and other topics, please visit our Knowledge Center at corpsyn.com. Thank you.